All right, good afternoon, everybody, and welcome to the full general laws meeting for January 30th. Clerk, if you'll open the roll for attendance. All right, clerk, close the roll. We have a quorum present. Okay, we have two of our subcommittee reports today. So we'll have housing and then professions and occupations. Before that, we got a couple of housekeeping items. And so first are administrative actions. The following bills are going to be re-referred out of here to different committees. And so we have House Bill 356, Delegate Fowler is being referred to appropriations. House Bill 1168, Delegate Cordoza is referred to Health and Human Services. And I will note that we did have somebody who was signed up virtually to speak for this, Brittany Whitworth. And so if Ms. Whitworth is online, that will go over to HHS and you can see when that comes up for a hearing over there. We have House Bill 1387, Delegate Leftwich, which will be referred to Health and Human Services. House Bill 1482, also from Delegate Leftwich, which will be referred to courts. And then House Bill 1485, Delegate Freitas, referred to AC and R. So do I have a motion to refer these in a block? So moved. All right, it's been properly moved and seconded. All those in favor say aye. Aye. All those opposed, those are referred. We do have one bill to be heard in full general laws committee. We didn't need to bring Delegate Tata here for House Bill 101. This one dealt with an issue concerning ABC and licenses for sports complexes and entertainment venues. And so up until not long ago, we had to have each of these different specific venues approved by our committee. Delegate Krizik actually passed an omnibus bill that has already gone through this committee and I think was up on second reading today that actually just gives ABC the authority to approve these without having to go through this committee for each and every one. So I think that'll help standardize the process. But with that, the appropriate motion would be to table House Bill 101. So moved. All right, it's been properly moved and seconded. Clerk, open the roll.
And she's a co-patron on Cruises.
Correct, yes. All right, clerk, close the roll. That bill is laid on the table, 21-0. Okay, then we also have a bill from Delegate I guess that's part of your report, Mr. Chairman. There we go. All right, getting ahead of myself. Delegate Simon, you have your Housing and Consumer Protection Subcommittee report.
Thank you, Mr. Chair. A number of bills that will be in a couple different blocks, but the first bill is a bill from Delegate Shin on common interest communities and the ban of use on pesticides. She asked that we carry that over to the 2025 session so she and the stakeholders can work and see if there's common ground to be had there. And I would so move.
Second. All right, it's properly moved and seconded. Is there any conversation or discussion from the committee members? All right, hearing none. This is a voice vote. All those in favor say aye.
Aye.
All those opposed, that bill is carried over to the 2025 session. Chairman Simon.
Yeah, Chairman Bulova, the next 5 bills are all recommended for reporting uncontested. So what I'd like to do is, if it's okay with you, is present those bills and we can vote all 5 of them in a block.
Thank you, Mr.
So the first of the 5 bill uncontested block is House Bill 352 from Delegate Glass. And I move the subcommittee recommended, had some amendments. I would move the subcommittee amendments.
Good. All right, this has been properly moved and seconded. All those in favor of the amendment say aye. Aye. All those opposed. All right, the bill as amended is before us.
All right, and so with the amendments, the bill allows, basically it aligns the Virginia Land Lieutenant Act with federal law regarding terminations for military personnel and stop movement orders. It allows certain military personnel to terminate a rental agreement upon receipt of a stop movement order issued in response to a local national, or global emergency that is effective for either an indefinite period or a period of not less than 30 days and prevents the service member from occupying the leased dwelling unit for residential purposes. So again, it just aligns us with federal law on that issue, and the subcommittee recommended reporting by a vote of 8-0. House Bill 477 from Delegate Coiner is an election diversion pilot program, and it extends the expiration date of the current eviction diversion pilot program to July 1st, 2025. Currently, the program is set to expire July 1st, 2024. Subcommittee recommended reporting by a vote of 8-0. House Bill 701 from Delegate Fagans has subcommittee amendments, which I now move.
All right, so it's properly moved and seconded. All those in favor of the amendment say aye. Aye. All those opposed, nay. The bill is amended as before us.
All right, and so the House Bill 701 requires landlords, unless impractical to do so, to provide a tenant with 72 hours notice within 14 days of routine maintenance. Current law requires a landlord to give at least 72 hours notice for such maintenance, but does not provide a maximum window of time for such notice. The subcommittee recommended reporting 8-0. And then House Bill 876 is the chairman's very excellent bill on the Resale Disclosure Act. And there's a committee substitute, which I would move. There's a committee substitute, which the subcommittee recommended, but there's a new substitute, which has been sent out to everybody. We made one line amendment to the committee substitute during the subcommittee session. And then LIS, the attorneys here at DLS told us they need to run that through proofing and editing. If you don't mind, I'll just tell you what we did there. And that had to do with the payment for financial updates to the resale certificate. And the new language reads, the seller shall be responsible for all fees associated with the preparation and delivery of the financial update, period. However, a settlement agent or other requesting party may pay such fees up front, regardless of whether such settlement agent or other requesting party requests to be reimbursed for such fees from the seller. Solving a problem where we're trying to allow third parties to pay for it, but ultimately not be responsible for it so they can seek reimbursement. And so with that one change, I would move the substitute.
All right. Council, do you have that? Is that properly in order? Okay. All right. All those in favor of the substitute say aye. Aye. All those opposed? All right. The substitute is properly before us.
Okay. So Chairman Bulova, that House Bill 876, in addition to making that change, provides that the failure to deliver a resale certificate within 14 days as required by the Resale Disclosure Act deems the resale certificate to be unavailable. It also grants purchasers 3 days from the date of ratification of the contract or the date of receipt of the resale certificate or notice that it's not available to cancel the contract. And finally, excludes from the resale certificate requirements of the Act an initial disposition to a lot to a person who is not acquiring the lot for his own residence. It also allows the resale certificate to be delivered to the person's authorized agent. The subcommittee recommended reporting 8 with substitute by a vote of 8-0. And then I think finally in the uncontested block, House Bill 917 from Delegate Shin, and I would move the subcommittee amendments.
Okay, is there a second? Second. All right, it's properly moved and seconded. All those in favor say aye. Aye. All those opposed, the bill is properly before us.
And this bill has to do with the definition of a real estate broker, and it adds to the definition of real estate broker any individual or business entity who sells or offers to sell, buys or offers to buy, or negotiates or otherwise deals in real estate contracts, including assignable contracts on 2 or more occasions in any 12-month period for compensation or valuable consideration. And the bill contains technical amendments to that section of the code. Subcommittee recommended reporting 8-0. And so as with the others, I move the 5 bills in the block report.
Do I have a second?
Second.
All right. Does any member of the committee have any questions, comments, wish to remove anything from the block? Hearing none, clerk open the roll. All right. Clerk close the roll. That bill reports 22, or those bills report 22-0. All right. Mr. Chairman.
Mr. Chairman, next on the list is House Bill 214 from Delegate Watts. And it has to do with common interest communities and residents that provide certain services. And it says it provides that a resident of a common interest community association who provides bookkeeping, billing, or record keeping services for such community for compensation shall be presumed to be an independent contractor. The bill also exempts common interest community associations from the definition of employer where a resident provides only such services. This bill codifies a opinion of the Virginia Employment Commission. The subcommittee recommended reporting 5-3, and I so move.
All right, it's been properly moved and seconded. Does any member of the committee have any questions or comments? Hearing none, clerk, open the roll. All right, clerk, close the roll. That bill reports 12-10. Mr. Chairman.
Mr. Chairman, House Bill 588 from Delegate McClure has a committee substitute. I move the subcommittee substitute.
All right, all those in favor of the substitute say aye. Aye. All those opposed? All right, the substitute's before us.
So House Bill 588 as substituted requires a landlord, prior to giving a tenant 21 days notice of his intention to terminate the rental agreement for a dwelling unit that has been damaged or destroyed by fire or casualty, to make reasonable effort to meet with the tenant, to discuss reasonable alternatives, and to offer the tenant a substantially similar unit if one is available. Current law allows the landlord to terminate such agreement by giving tenants 14 days notice of his intention to terminate on the basis of the property being substantially impaired. The bill requires the landlord, upon receiving a request from the tenant, after the tenant has received such notice, to reevaluate the extent of damage and habitability of such unit. So essentially goes from 2 weeks to 3 weeks and gives the tenant an opportunity to say, wait a second, this isn't so bad. I can live under these circumstances. Please don't terminate my lease. The subcommittee recommended reporting by a vote of 7-1, and I so move.
All right, it's been properly motioned and seconded. Does any member of the committee have any comments or questions? Delegate Arnold.
Thank you, Mr. Chair. Mr. Chair, I voted against this bill in subcommittee, but after speaking with the patron and relevant stakeholders, they have allayed my concerns about this bill. I just wanted to inform the committee of my vote and the reason therefore.
That's excellent. Thank you. All right. Any further comments, questions? If none, clerk, open the roll. All right. Clerk, close the roll. That bill reports with substitute 21-1. Mr. Chairman.
House Bill 880 is another excellent bill from Chairman Bulova. And there's a subcommittee substitute. I move the subcommittee substitute.
Second.
All right. All those in favor of the substitute, please say aye.
Aye.
All those opposed? All right. Substitute's properly before us.
And Mr. Chairman, what your bill does is it prohibits certain bills from, to enforce a lien from being entertained if the real estate is the judgment debtor's primary residence and the judgment is for assessments levied by certain common interest community associations, if the amount secured by one or more judgments, exclusive of interest and costs, does not exceed $5,000. The bill also requires such common interest community associations to maintain individual assessment and account records and restricts access to such records to the unit owner of the property subject to such assessments, the governing body of the association, the management agent, if there is one, and any legal counsel for such association. Finally, the bill requires such associations to maintain records of any recorded lien during the effective duration of such lien. The bill is a recommendation of the Housing Commission, and the subcommittee recommended reporting with substitute by a vote of 6-2, and I so move.
All right, it's been properly moved and seconded. Any member of the committee have questions or comments? Seeing none, clerk, open the roll. All right, clerk, close the roll. That bill reports a substitute 22-0, and apparently, Mr. Chairman, you explained it better than I did. So,
I think that's probably what happened. House Bill 1209, that's the only explanation. House Bill 1209 from Delegate Bulova, another excellent bill, has no substitute. This is Common Interest Communities Reserve Studies. I'm just checking, was I the one no on this one, or was it somebody else? Because my concerns have been assuaged if I was the only one who was a no on this, but let me go ahead and explain the bill. So 1209 removes certain provisions of the Property Owners Association Act and the Virginia Condominium Act that authorize associations governed by such acts to rescind or reduce certain assessments necessary for the maintenance and upkeep of the common area or other association responsibilities, including maintenance, repair, and replacement capital components. The bill also authorizes such associations to borrow money for any valid purpose and assign all revenues to be received by such association to its creditors. Finally, the bill defines the term reserve study as a capital budget planning tool used to determine the physical status and estimated repair replacement costs of capital components, and an analysis of association funding capacity to maintain, repair, and replace capital components. Mr. Chairman, I'm going to ask you a question because I probably should have asked you before. You showed me an amendment. Was that an amendment to this bill? And is that going to be done in the Senate?
That is an amendment to this bill. And Council, if you could report the line amendment.
Thank you, Mr. Chairman. We have line amendments from Delegate Bulova on line 88 of the introduced version. After provides, strike otherwise, insert greater or lesser authority. On line 89, introduced after 4, strike any valid purpose, insert maintenance, replacement, repair, and restoration of structural components, and for funding recommended reserves. And on line 91, introduced after to time, insert for such purposes. On line 293 of the introduced version, after provide, strike otherwise, insert greater or lesser authority. On line 294 of the introduced version, after 4, strike any valid purpose, insert maintenance, replacement, repair, and restoration of structural components and for funding recommended reserves. And on line 296, introduced after association, insert for such purposes.
Mr. Chair, can I speak to your amendment?
Certainly. And then we have Delegate Leftwich, I think, if it's to the amendment, Delegate Leftwich.
Okay, so speaking to the amendment, Mr. Chair, so with the discomfort I had that caused me to throw up the one no vote was the language about allowing the association to borrow, the board of directors rather, to borrow pretty much as much money as they wanted for whatever reason they wanted, as often as they wanted, if the underlying declaration didn't prevent them from doing that. I was concerned that was a little bit broader in scope than the intent of the bill, which is to deal with reserve studies and maintenance. And so the language that what the amendment does is it limits the scope of that borrowing to be what's necessary essentially to maintain those reserves or to set up reserves for these capital improvements. And so with this language, should it be adopted, my discomfort with the bill would go away.
Good. All right. Do we have a second just to get it properly before us? All right. Delegate Leftwich.
Okay. Thank you, Mr. Chairman. And so that was my concern. But as a question, I guess either to the chair or to the patron, whoever wants to address it, is there a cap on the amount they can borrow? And I'll go ahead and ask the second question now, so maybe address it, provide an answer at the same time. Does any of this have to be approved by the association prior to the board? So I know, like, I've been, advised clubs and associations, and many times the bylaws will say the board can borrow up to $5,000, $10,000. Anything more than that, it has to be approved by the shareholders or the members or whatever. Is there, are any of those safeguards built into this?
Yeah, and again, Delegate Leftwich, so it is directed at giving the board that authority because one of the problems we're trying to address is getting the membership to do that can be painfully difficult as you're aware. And so this allows the board to be able to act on behalf of its membership. There is not a specific cap to that. And primarily the reason for that is because I don't know that we could anticipate what kind of reserves or capital needs might need to be addressed under these circumstances. And so the issue that really kind of brought this to light was the situation in Florida with the collapse of one of their condominiums that I think it wound up killing about 90 or so people. In that case, it was about $16 million worth of capital needs that they had. And one of the reasons they had a really hard time with that is that they couldn't borrow to be able to spread the pain of those assessments out over a longer period of time. And so totally agree with what Delegate Simon is saying to make sure that this is related specifically to capital and capital reserves, but didn't want to second guess what a maximum might need to be for the amount you could borrow. Yep. All right, excellent question though. All right, the amendment is before us. All those in favor of the amendment, please say aye.
Aye. Aye.
All those opposed. All right, any further comments or questions with respect to the bill?
So, Mr. Chair, with that amendment being adopted, I'm comfortable moving. The subcommittee recommended reporting 7-1. And even though I was the one no, I'm now comfortable moving that it be reported. I move to report.
Okay, it's properly been moved and seconded. Clerk, open the roll. clerk close the roll. That bill reports with amendment 21-0. Mr. Chairman, your next bill.
So next bill is House Bill 597 from Delegate Price. And the only reason this is not in the uncontested block is because the original motion was to, recommendation was to report and refer to courts of justice. But I have received further information that courts of justice is apparently no longer interested in this bill. So let me explain it, and then I'll have a different motion than what the subcommittee recommended. This bill provides that if a condition exists in a rental dwelling unit that constitutes a material noncompliance by the landlord with the rental agreement or with any provision of law, that, if not promptly corrected, constitutes a fire hazard or serious threat to life, health, or safety of tenants or occupants of the premises, a locality may institute an action for injunction and damages to enforce the landlord's duty to maintain the dwelling unit in a fit and habitable condition. So essentially, this allows localities the authority to step in on behalf of tenants who might not be able to afford to hire a lawyer to enforce certain noncompliance when it has to do with a threat to life, health, or safety of the occupants. The subcommittee recommended reporting and referring to the courts of justice. However, since we don't need that, I would move, and that was by a vote of 8-0, by the way, but I would move that we report.
All right, it's been properly moved and seconded that we report. Members of the committee, comments, questions? All right, hearing none, clerk open the roll. All right, clerk close the roll. That bill reports 14-7. Mr. Chairman.
All right, and I think the last one on my agenda here is a report and refer. So this is HB 1105 from Delegate Carr. That creates the Zoning for Housing Production Fund to be administered by the Department of Housing and Community Development. The bill requires monies from the fund to be awarded as grants to localities by application to the department for the purposes of creating and maintaining affordable housing in mixed income communities as defined in the bill. To be eligible for a grant from the fund, a locality is required to make a change to its zoning ordinance in accordance with the requirements of the bill. The bill has an expiration date of July 1st, 2029. The subcommittee recommended reporting and re-referring to the Committee on Appropriations by a vote of 8-0, and I so move.
Okay. And Mr. Chairman, I think we have amendments that we need to
And
move.
first I move to adopt the subcommittee to adopt certain amendments. So I move the subcommittee amendments.
Second.
All right, all those in favor of the amendment say aye.
Aye.
All those opposed. All right, the bill
And
is
with
amended
that,
before
the
us.
subcommittee recommended reporting and re-referring to the Committee on Appropriations by a vote of 8-0, and I so move.
Okay. That is properly before us. Any members of the committee have comments or questions? Okay. Clerk, open the roll. All right. Clerk, close the roll. That bill reports with amendments and is re-referred to appropriations on a vote of 21-0. Mr. Chairman, does that wrap up your subcommittee report?
Thank you. That's my short report. The longer one will be next week.
Very good. All right. All right. Chair Delaney, Professions, Occupations, and Administrative Processes.
Thank you, Mr. Chair. First, from our committee, we have HB 722, patroned by Delegate Weber, and that was a request of the patron to strike the bill. So I so move.
All right, it's been properly moved and seconded that we strike HB 722. Comments or questions from the committee? If not, clerk, open the roll. All right, clerk, close the roll. That bill is stricken from the docket, 21-0. Madam Chair.
Thank you, Mr. Chair. Next, we have 7 bills that I'll reported out uncontested, of which I believe we can vote in block, so I will present each one. Starting with HB 383, patroned by Delegate Reeser. This bill increases from 8 to 11 the number of hours of continuing education an applicant for licensure as a real estate broker or salesperson shall complete on the topics of ethics and standard of conduct, fair housing, legal updates and emerging trends, real estate agency, and real estate contracts. The bill also decreases from 8 to 5 the number of hours of general elective courses such applicants shall complete. The bill directs the Real Estate Board to adopt regulations to implement the provisions of the bill against current licensees, beginning in such licensees' next full renewal cycle, following the effective date of such regulations. The bill reported from our subcommittee 8-0, and we will move that in a block. So Mr. Chair, I'll move to the next. Would that be the?
Yep, Madam
Okay,
Chair.
all right. Make sure we do the block correctly. Next, we have HB 517, patroned by Delegate Hope. This bill designates the honeybee as the official state pollinator. This bill also reported from the committee 8-0.
Right. No puns?
I have nothing.
Okay.
I'm leaving that to the.
Disappointed, Chair.
I'm sorry to
Delaney.
disappoint. I'm sure there'd be more disappointment if I tried. I promise. There are better minds than me that are literally buzzing around my head right now. Mr. Chair, next we have HB 680, patroned by Delegate Lefwich. This bill requires the Department of Human Resource Management develop a statewide recruitment policy designed to provide guidance to state agencies on how to remove post-secondary degree requirements from hiring considerations and recruit qualified employees utilizing appropriate baseline requirements, the specifics of which are outlined in the bill. Recommend reporting from our subcommittee 7-0. Next, we have seven.
Madam Chair?
Yes.
If we could go back, I think we missed House Bill 613.
Oh, my apologies. Yes, we did. My apologies, Delegate Price. HB 613, patroned by Delegate Price. This bill changes the sunset of the Henrietta Lacks Commission from July 1st, 2026 to July 1st, 2024. And it recommends reporting from the subcommittee 8-0. Moving then ahead to HB 728, patroned by Delegate Maldonado. This bill permits the Department of General Services to establish procedures for a buyback or trade-in agreement with a purchasing vendor for surplus technological equipment. Recommends reporting 7-0. Next, we have HB 814, patroned by Delegate Munden King. This bill requires the Virginia Tourism Authority, in consultation with the Library of Virginia and the Virginia African American Advisory Board, to create standards for the authority's publication and advertising materials to ensure all such materials accurately identify parcels of real property in the Commonwealth with the history linked to slave ownership and accurately depict the contributions of Black Virginians to any such parcel of real property, and acknowledge the horrors of slavery in the Commonwealth by publishing a list of slave-owning properties in the Commonwealth. The bill recommended reporting from the subcommittee 7-0.
Madam Chair, I believe we have a substitute.
Oh,
we
yes,
need to
I'm
adopt
sorry.
on that one.
Yep, you're right, Mr. Chair. So first, I will move the committee substitute.
All right. All those in favor of the substitute, please say aye. Aye. All is opposed. All right, Madam Chair.
Thank you, Mr. Chair. So the substitute is before us, and what I had outlined in my remarks on the bill, the subcommittee did recommend reporting with substitute 7-0. Next, we have HB 1133, patroned by Delegate Carr. This bill renames the Virginia College Savings Plan as the Commonwealth Savers Plan, and that bill was recommended reporting from the subcommittee on a vote of 8-0, and I so move all aforementioned legislation from the committee.
Okay. Is there a second?
Second.
All right. Anybody desire to take a bill out of the block? Is there any discussion from the committee? Hearing none, clerk open the roll. All right. Clerk close the roll. That block of bills reports 22-0. Madam Chair.
Thank you, Mr. Chair. We have two more bills left that have both report and re-refer requests coming from the subcommittee. First, we have HB 53, patroned by Delegate Ware. This bill provides that no action for damages or other relief alleging that a certified general real estate appraiser, a certified residential real estate appraiser, a licensed real estate agent appraiser, or appraisal management company committed malpractice or negligence or an error, mistake, omission, or breach in an appraisal or appraisal report, whether based on a contract, tort, shall be brought unless it is filed in a court of competent jurisdiction and proper venue within 5 years from the date of the alleged malpractice, negligence, error, mistake, omission, or breach. The bill provides exceptions for actions alleging fraud and proceedings initiated by the Real Estate Appraiser Board. The bill provides that any action for damages or other relief alleging that a certified general real estate appraiser, a certified residential estate appraiser, a licensed residential real estate appraiser, or an appraisal management company committed malpractice or negligence, or an error, mistake, omission, or breach in the appraisal or appraisal report July 1st, 2024, shall be filed in a court of competent jurisdiction and proper venue within 2 years of the occurrence of such malpractice, negligence, error, mistake, omission, or breach, regardless of the date of the discovery of such occurrence. This bill recommends reporting and being re-referred to the Committee on Courts of Justice at a vote of 7-0, and I so move.
Is there a second?
Second.
Okay, and that description reminded me why this should go to courts.
Mr. Chair, those were exactly my thoughts as I read that description, that it does not surprise me that we are referring this to courts as well.
Okay, any comments, questions from members of the committee? Hearing none, clerk, open the roll. All right, clerk, close the roll. House Bill 53 is reported and referred to the Courts of Justice Committee. Madam Chair.
Thank you, Mr. Chair. And finally, we have HB 317, patroned by Delegate Gardner. This bill authorizes the Office of Children's Ombudsman to request the Department of Social Services, local Department of Social Services, a children's residential facility, or a child placing agency grant access and provide consent to interview children in foster care who are the subject or the complainant in an investigation. This bill recommends reporting from the subcommittee 8-0 and with a referral to Health and Human Services, and I so move.
Second.
All right, it's been properly moved and seconded. Any member of the committee have comments or questions? If not, clerk will open the roll. All right, clerk, close the roll. That bill reports and refers to Health and Human Services on a 22-0 basis. Madam Chair, does that complete your report?
Mr. Chair, that does complete my report. Thank you.
All right, thank you very much for the hard work of our two subcommittee chairs. If you thought that was good, just wait for the ones coming up next. Stay tuned for ABC Gaming, which will be followed by procurement after general laws. And I can see the excitement building in the room. So do I have a motion to adjourn?
So moved.
Is there a second? All those in favor say aye. Aye. All those opposed, we are adjourned. Thank you.